up with you again and have a little talk this morning. For those new members to the group, my name is Hein Duisel. I'm a Senior Conveyancing Associate at STBB in Somerset West. And what we're going to talk about this morning are the different types of marriages and how that affects the documents that you will sign with your clients, like, for example, mandates and offer to purchases, etc. Because in South African law, each and every marriage will have certain rules and regulations. The parties will have certain rights. They will have certain authorities to do certain things. Sometimes you need the consent of your spouse to do things. Sometimes you don't. So we're going to have a look at the different scenarios and when you need consent, when don't you need consent, etc., etc. So just as a brief overview, the different types of marriages that we get in South Africa and that you will have to deal with in your business and in your transactions with purchasers and sellers are marriages in community of property. We get marriages out of community of property. Then there are also parties that are married according to Muslim rights. So what are those rules and regulations? How do we describe them in our offer to purchase? Who must sign those documents? We've got marriage according to the customary laws of South Africa. We'll have a look. There's a slight difference in marriages prior to 2000 and after 2000, when the Recognition of Customary Marriages Act came into operation in South Africa. Then we've got foreign marriages. We've got civil union marriages. So the civil union marriages are marriages which are predominantly same-sex marriages. And then we've got the common law marriages, or the domestic partnership relationships, and we'll have a look at that as to what the rules and regulations are with regards to that. So if we just first of all have a look at marriages in community of property. The thing to remember with marriages in community of property is you are seen as one person. So hubby and wife, you are now seen as one entity, one person. So yes, your rights that you've got with regards to how you manage the estate, you've got exactly the same rights. You can dispose of assets, you can sell assets, you can purchase assets, you can enter into contracts for debt, you can manage the joint estate. So you can do certain things on your own with regards to the joint estate that you've got, and you've got exactly the same power. Husband and wife, you can both buy, sell assets, motor vehicles, take out contracts for cell phones, incur debt, take out loans, personal loans, etc. You've got exactly the same rights, and you can manage the joint estate and carry on regardless. However, if you decide a person is married in community of property, husband or wife, doesn't matter, you cannot, without the consent of the spouse, of your spouse, of the other party, you cannot alienate immovable property. You cannot sell immovable property. You cannot register a mortgage bond over immovable property. You can't burden the immovable property with a servitude or with any other real right over the property. So if you married in community of property, and this is where it is important to you and me, because we deal with immovable property. So the Matrimonial Property Act says that if you are married in community of property, and if you dispose of immovable property, a house or a flat or land or a farm, whatever immovable property, if you sell that, then you cannot do that without the consent of your spouse. Then your spouse must countersign those documents, or you cannot take out a mortgage bond over that property because your spouse will have to consent to the bond being taken out. And you can't take out or register a servitude or any other real right, a usufruct or anything like that over immovable property without the consent of your spouse. So that is important for incommunity of property. So in our lives, so as soon as you hear a purchaser or a seller that wants to buy or sell, look, we'll get to purchasing just now. But if a party is selling a property, and we get scenarios, let's say, for example, I bought a property 10 years ago, and I was unmarried at that stage. So in the title deed, I'm still recorded as unmarried. Now, I want to sell a property, but in the meantime, I got married. I got married in community of property. So now I go to the attorneys or to the estate agent and I say, hey, I want to sell this property, please. The property is in my name. I was unmarried when I bought this property. It's in my name. I want to sell this property. Right, Hein, how are you married? Are you married out of community of property now? Or no, I'm married in community of property now. No, well, then your spouse must sign with you. No, but this property wasn't in her name when I bought it 10 years ago. Doesn't matter. By law, by the Matrimonial Property Act, if you are married in community of property now, you've got one estate. And because you are selling, you are alienating, you are disposing of an immovable property. The legislation say that you can't do that without the consent of your spouse. So, unfortunately, your spouse will have to sign the documents with you because you are now married in community of property. So, the day that you got married, automatically your spouse became a half owner in that property. Automatically. There had to be no endorsements on the title deed to show that she's now a half share owner. Not at all. Not at all. It's by operation of law, she's automatically a half share owner and she will have to sign all the documents. Very often, we'll also get, well, not very often, but people ask these questions. They say, okay, I want to buy this property in my name. Please, I'm going to pay the full purchase price in cash from my bank account. I'll show you the proof that I've got the money. I want to pay the full purchase price. So please, I want to register the property in my name. Okay, how are you married, sir? No, I'm married in community of property. Well, it must register in you and your wife's name because you are married in community of property. No, but I'm paying for the purchase price on my own. She's got nothing to do with this property. That's irrelevant, completely irrelevant. Because of the fact that you are seen as one, you are married in community of property, the property will have to register in your name and your wife's name. Doesn't matter whether you pay the full purchase price or not, it's irrelevant. So that's important to keep in mind, and that's obviously the benefit of a marriage out of community of property. Because if you got married out of community of property, absolutely, you can buy, sell, do whatever you want to do without the consent of your spouse. So each party, if you are married out of community of property, each party has got his and her own estate. So you operate separately. You're not seen as one person like a marriage in community of property. If you're married out of community of property, you do your thing. You buy, you sell, you do whatever you want to do. You don't need the consent of your spouse at any stage to do anything if you are married out of community of property. So you will have full contractual capacity to register immovable property, buy or sell, whatever you want to do. You can register servitudes, you can register usufructs, real rights. You can do whatever you want to do if you are married out of community of property. So the spouses act independently from each other. Each one signs documents pertaining to the registration process, completely independent from one another. The one doesn't even have to know what the other one is doing with regards to obviously property purchasing and selling. They're completely separate, own contractual capacity. So then the parties are cited, the full name, ID number, and married out of community of property. That is how they are cited. at the deeds office and on the transfer documents that he or she will sign. Obviously, if they own a property together, then yes, of course, they both will sign, but it's purely because they both own the property. It's not because the one is consenting to the sale, not at all. Then, if we have a look at Muslim rights, some people get married according to Muslim rights. Normally, what would happen is um, the parties will go to the Imam in order to get married according to the traditions and the customs of the the Muslim faith and religion. So they'll go to the Imam, they'll get married, and they then get a little certificate from the Imam to confirm that they are married according to Muslim rites, which they will then get. So we describe them in our documents as married according to Muslim rites. However, legally, if they are married according to Muslim rites, they are seen as unmarried because that marriage according to Muslim rites is not recognized by South African law. So let's say, for example, you deal with a guy or a lady that wants to sell a property. You ask them, how are you married? I'm married according to Muslim rites. You can take it as if they are not married. So if it's in the wife's name, married according to Muslim rites, she can sell without the consent of the husband. If it's in the husband's name, vice versa, he can sell in his own capacity, he doesn't need the authority, and it goes for purchasing as well. You can buy, you can sell, you can do whatever you want to do because it's as if you are unmarried. So you don't need the consent of anybody. You don't need the consent of your spouse if you want to buy or sell property and you are married according to Muslim rights, because it is as if you are unmarried for South African law purposes. However, in certain instances, the Imam is also registered as a marriage officer in terms of the Marriage Act. So sometimes the Imam is registered as a marriage officer, and in that scenario, if the Imam married the couple in terms of his appointment as a marriage officer, then they will be married in community of property. They won't be married according to Muslim rights. So as soon as the parties received a marriage certificate from the Department of Home Affairs, they are married according to the laws of South Africa, either in community of property or out of community of property. So they will obviously be married in community of property to each other if they never entered into an antenuptial contract before they got married in front of the Imam on their wedding day. If they did enter into an antenuptial contract before they got married, then they will be married out of community of property. So it is important. So what we do is, when we consult with clients, and this will obviously be applicable to you as well. So that's why I'm mentioning it to you. So when we consult with clients and they say, hey, we are married according to Muslim rights, we'll say, right, great. Where's your marriage certificate? Where's the certificate that you got? If they provide us with a certificate that was provided by the church, the Muslim church, that was signed by the Imam, they're married according to Muslim rights, and it's considered unmarried. If they provide us with a copy of a Department of Home Affairs marriage certificate, then they are married either in or out of community of property. And then obviously we'll ask them, but do you have an antenuptial contract? Yes or no? No, I don't have an antenuptial contract. Well, then you're married in community of property because you've got a marriage certificate. That Imam in front of whom you got married is registered as a marriage officer in terms of the Marriage Act. And because he married you and he got a marriage certificate for you, you married in community of property, or out if you had an ANC. So there is a difference with regards to marriages according to Muslim rights, because the one will be described as Muslim rights in terms of any deed. If it was just in front of the imam, who is not registered as a marriage officer, it's then according to Muslim rights, and you are seen as unmarried. If you got married in front of an imam who is registered as a marriage officer, so you, after your marriage, you got a marriage certificate from the Department of Home Affairs, then you married in community of property or out of community of property if you had an antenuptial contract in place before you got married. So that is the difference in the Muslim marriages. It is always good to ask for a copy of that marriage certificate when they got married, and then you'll be able to pick up whether it was in front of a imam that is registered as a marriage officer or not, whether it's just a traditional or customary Muslim marriage, and the certificate that was issued by the imam with all their figures and printing, etc. In that case, they are seen as unmarried.
Hi, and there's just a question here. It says, what if a Christian marriage is married in a church, but the minister is not a registered marriage officer?
Well, then you can only get married in front of a marriage officer. So, for example, Aniki could see our director here. She is registered as a marriage officer, so she can wed people. She can go and do ceremonies, but you've got to write exams. You've got to do a lot of stuff in order to become a marriage officer, to legally marry two people. So if you go to church and you in front of the Christian marriage, as you said, and you get married in front of somebody that is not a registered marriage officer, in terms of what tradition are you going to be married? Because in terms of the customary, that is why. If you get married in front of imam that is not registered as a marriage officer, you get married according to Muslim rights. Who is not registered as a marriage officer, you are not married. And that's the reason why you are not married, really, because you were not married in front of a marriage officer. So yes, we can describe you as married according to Muslim rights, but it means nothing. It wasn't done in front of a marriage officer, so you are seen as unmarried. So I suppose if you want to go get married, a Christian marriage in a church, absolutely, and you want to get married by the dominee or the minister or the priest or whatever, who is not registered as a marriage officer, I'm sure you can say, but I want to be described as married according to Christian rights. Well, it's fine, but you're not married. You are unmarried. You can only legally get married in front of a marriage officer that is certified as a marriage officer and that went through the whole process to register as a marriage officer. But no, we don't, in South African law, well, I've never seen married according to Christian laws or the Christian faith or Christian rights or whatever like that. I haven't seen that. But again, you can describe yourself whatever you want to describe yourself. You can describe yourself married according to Muslim rights, Christian rights, Hindu rights, whatever you want to describe. But the fact is, if you weren't married in front of a marriage officer, then you're seen as unmarried. So you can describe yourself whatever you would like to, but you are unmarried. I hope that helps. Then, customary marriages. So, customary marriages, the recognition of customary marriages came into operation, to recognize the indigenous African people of South Africa, because there are obviously certain traditions that indigenous African people go through in order to get married, with not going necessarily to a marriage officer that is registered as such. So there are certain rules, regulations with regards to people married according to customary marriages. Um, and people are not described as being married according to customary marriages. It is just the way that they enter into the marriage. So both spouses will have the same rights, they will have the same powers to enter into agreements, to buy and sell property. At the end of the day, what we're getting to is the fact that customary marriages are also seen as in or out of community of property. Easy as that, but we'll get to that, and I'll show you how we get to that. So, although the spouses are married according to customary marriages, they have a duty to ensure that that their marriage is registered. So, the Recognition of Customary Marriages Act says that in order for two people to marry in terms of customary rules and regulations, they have to be above the age of 18 years. Both parties must consent to be married in terms of that customary rules and regulations. The marriage must be negotiated and celebrated, actually. And then obviously no spouse of a marriage entered into under a marriage act can enter then into a customary marriage as well. You can't do that. And the husband, if a husband is married according to the customary laws, the existing wife must consent to proposed marriage. So if they are married according to the customary laws, the wife must consent to him entering into another customary marriage as well, like Jacob Zuma, etc., 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 that get married in customary, by way of a customary laws and procedures to more than one wife, but you need the consent of your existing spouses to enter into that customary relationship or marriage with the next spouse. So the spouses have got the same legal status, they've got the same power and authority in terms of the law. They're regarded as equal. Husband and wife are equal in the eyes of the law in any event. However, the marriages must be registered. So that recognition of Customary Marriages Act says that if you do have a customary marriage or a traditional marriage, you have to register that marriage within 3 months after you got married with the Department of Home Affairs, obviously. And what is a customary marriage? It says that a customary marriage is a marriage that was negotiated in terms of the customs of the community, and it was celebrated in terms of the customs. So the courts, it's very difficult to decide whether there was a customary marriage or not, because the rules and regulations of the custom changes on an annual or daily or monthly basis. What the customs are today are not necessarily the customs tomorrow. But you have to register that marriage within 3 months after you got married. If you don't do it, it does not mean that the marriage doesn't exist or is null and void. Not at all. It is then just difficult to prove that you're married according to the in terms of the Recognition of Customary Marriage Act. In terms of a customary marriage, you then have to go to court to prove, and what you have to show to the court was that on this date we had a marriage, we had a celebration, there was negotiations took place, like lobola. So lobola is seen as the negotiations that took place, and it must also be celebrated. And the court said, well, what is celebrated? The handing over of the bride is seen as the celebration of the marriage, but it's not the be-all and end-all. The wife might not even be present at the customary marriage. So we take it on piecemeal, but if there was, so the courts have decided that if there was lobola, if there was negotiations taking place between the two families, there is a customary marriage. They are not too concerned about the celebration, because the celebration vary from one group to the next, and how do you enforce that? So in Gumede versus the President of the Republic of South Africa and others, monogamous customary marriages entered into before the commencement of the Act are now deemed to be income of property. So before the commencement of the Recognition of Customary Marriages Act, before this Act came into operation, the courts have decided that all those parties that were married according to customary marriages are income of property. They are income of property. That is it in terms of the laws of South Africa. So those rules and regulations will apply to them. With regards to buying and selling property, etc., etc., etc. Customary marriages entered into after the commencement of the Act in 2000 can either be income of property, alternatively, out of income of property, if the parties entered into an antenuptial contract before the customary marriage, they will be seen as out of income of property. But how do you change your matrimonial system now? So let's say a couple got married before 2000, in terms of the customary laws, now they're seen as income of property by law. They can change the matrimonial system. They can change it to out of income of property, but obviously they will have to bring a court application in order to do that. So they have to approach the courts and apply to court to have it changed from income of property to out of income of property, and the court will have a look. They'll have a look to see whether there is sound reasons in order to grant them this right to change the matrimonial system. Maybe the husband or the wife are big businessmen or businesswomen that needs to operate on her own. She cannot obtain the consent of a spouse every day when she buys hotels and etc., etc., etc. They'll also have a look whether sufficient notice was given to all creditors. So they'll place an advert in newspapers to say that, look, these two people are married income of property. They got married according to customary laws of South Africa, but they want to change the matrimonial system to out of income of property. Are there anybody out there that objects to this? And then if no one objects to it, then the court will say, well, okay, that's fine. If no one is prejudiced, no one objected to it, and there are very good reasons why you want to be married out of income of property, then we'll grant you that court order to be married out of income of property. But as you can see, customary marriages fall either in income of property or out of income of property, the same as most other marriages, including Muslim marriages. If the Muslim marriage was solemnized in front of a registered imam as a marriage officer, Muslim marriages will also be in or out of income of property, depending on whether they registered a nuptial contract before they got married. If they did, then they married out of income of property. The same with customary marriages. You are entitled legally to marry according to the customary laws, but did you register ANC or not? Because that will determine whether you married in or out of income of property. Then, if we have a look at foreign marriages, here in South Africa, we've got a very good idea. If you tell me you are married according to Muslim rites, I've got a very good idea to ask you for your marriage certificate in order to determine whether you're really acting married according to Muslim rites. Because if the marriage officer isn't registered as a marriage officer, then you're not married. You'll be described as married according to Muslim rites, but you're actually unmarried and you can do what you want to do on your own. If you are married according to Muslim rites, but the imam was registered as a marriage officer, well, then you can be married in or out of income of property like everybody else. If you had an ANC, you'll be out and you can do whatever you want to do. You can buy and sell property, but if you didn't have an ANC, then you married in. Then you need your spouse's consent for when you want to sell property, buy property, register mortgage bonds, etc. The same with customary marriages, as we saw, that yes, customary marriages, like Muslim marriages, you can go and get registered in terms of those marriages, but customary marriages, well, was there negotiation? Was there celebration? Yes, okay, fantastic. Then you are seen as married in income of property. unless you registered the ANC before you got married. Then you are married out from your property, and then you don't need your spouse's consent, etc., etc. Now, when it comes to foreign marriages, we are not so clued up because a foreign marriage is a marriage anywhere outside of South Africa. So if you got married in Namibia, Botswana, Zimbabwe, Mozambique, America, New Zealand, Australia, the electricity just went off, guys. So if I do lose you, I'll come back on. And I think I lost you, didn't I? Yeah, there we go. I think we're up and running still. So foreign marriage.
You. We didn't lose you.
Thank heavens for that. Thank you for the generator that kicked in. So foreign marriages, we don't know. So if somebody walks into my office and says, "Hi, I want to purchase a property. I am married according to the laws of Papua New Guinea." I don't know what those laws state. I don't know whether they've got similar marriages like us, like we do, in or out. When do you need your wife's consent? I don't know. So the rule is that when you sell a property, dispose of a property, or you register a mortgage bond over a property, and you are married according to a foreign marriage, whatever the foreign marriage is, you need to be assisted by your spouse. Not when you purchase. So when you purchase a property as a foreigner, so he walks into my office, Piet Pompies says he wants to buy a property. I said, "Piet, how are you married?" "I'm married according to the laws of Antarctica," whatever. It's a continent. Anyway, the laws of Mauritius. That's fine. What we will do is we will describe you, where's your marriage certificate, all that. So we'll ask the questions. And he can purchase the property in his name, married according to the laws of Mauritius. No problem. I don't need to see your spouse. I don't care who she is. It's irrelevant to me because you are buying property. That's fine. However, as soon as you sell that property, we don't know. What are the rules and regulations in Mauritius? Do they have similar things to South Africa? Because if it's in community of property, then your spouse must consent. If it is out of community of property, then obviously, yes, your spouse does not need to consent if the property is just in your name. But we don't know what those rules and regulations are. So in South Africa, if you sell a property and you are married according to a foreign law, whatever country's laws it is, your spouse will have to assist you so that we can safeguard ourselves. We can be satisfied that, Piet Pompies, you are married according to laws of Mauritius. You are now selling a property. We don't know what those rules and regulations are. So unfortunately, your spouse will have to assist you so that we know that she knows and she has authorized the sale of this property. So that is the reason why, if it's a foreign marriage and you are selling a property, the spouse will have to assist you purely because we don't know what those rules and regulations of that country is, whether they require consent or not. So as a blanket, free for all, the same rule applies to everybody. If you've got a foreign marriage and you sell a property, your spouse must assist. Then we're safe. The same with the mortgage bond. So let's say, for example, Piet Pompies, married according to the laws of Mauritius, buys the property in his own name, no problem, but he takes out a mortgage bond. Then the bank is going to say, Piet Pompies, we need your wife just to assist you with taking out the mortgage bond, please. Yes, the property can register in your name because you are buying. So yes, in your name, no problem. But the bond, you will have to be described as Piet Pompies, your ID number or date of birth, married according to the laws of Mauritius, and duly assisted by my spouse in as far need be. So your spouse will just have to countersign the documents with you, just so that we as the bank and the deeds office and everybody knows that your spouse is aware of this, what you are doing. and that she has consented thereto, because we don't know whether or not you need consent in terms of the laws of Mauritius, but we have safeguarded ourselves, we have received the consent, and the transaction can proceed. So that is why in foreign marriages, when you are selling a property or you are taking out a mortgage bond, yes, the property can register in your name on your own, and the bond in your name on your own. No problem. But your spouse must assist you, because we don't know what the rules and regulations of that country is. So all spouses must assist in foreign marriages. So there was also a case, I'm just reading this now, in Frankel's estate and another versus the master and another, 1950 case. It was concluded that the conclusion at which I arrive. Okay, but foreign marriages as well. This is also one thing that I just want to mention. Let's say, for example, parties get married in South Africa. So I've had people purchasing property in South Africa. The husband was from Canada. The wife was from the UK, from England somewhere. They came to South Africa, they got married here. In South Africa over December. They decided while they were here to purchase a property because they liked South Africa, but they wanted to purchase a little place as a holiday place, lock up and go, fantastic. So we've got to describe them as married because they got married. But the wife is from the UK, the husband is from Canada. So according to what laws, and they got married in South Africa, what laws will be applicable to that marriage? So the South African law says that. Have a look at the domicilium of the husband. I know it is sexist, but that's what the law says. What is the domicilium of the husband? In my scenario, the domicilium of the husband, and the domicilium is what do you consider as your home? You know, you can travel overseas to go on holiday, to go and get married, to do whatever. But what do you just consider as home? Where are you going to return after these things, these wanderings that you do through the world? What do you consider to be home? Where are you going to go back to that you consider your home? And in my scenario, the husband, his domicilium was Canada. He was going to go back there. He works there. The missus will join him from the UK. She's going to go back to the UK as well. She'll join him in about a year's time. She'll go to Canada and settle permanently with him in Canada. So the domicilium is whatever the domicilium of the husband is. So in my scenario, I asked the husband, what is your domicilium? What do you consider as home? Where are you going to go to now? Where are you going to go and work and stay for the unforeseen future, where you don't have any consideration of moving from? He said, Canada. I'm moving to Canada. I'm moving back to Canada. I'm just going back home. I've got work. I'm going to stay there for the unforeseen future. I mean, I don't know whether I'm going to move to the UK maybe later or move to South Africa when I retire. But for the time being, Canada is my home. So the parties were described, yes, they got married in South Africa. But you follow the law of the domicilium of the husband. And in this scenario, it was Canada. So when the husband and wife came to see me to buy property, they said, look, here's our marriage certificate. We got married here in South Africa last weekend. We want to buy a property. How are we going to be described in the offer to purchase and the title deed, etc.? Well, hubby, what is your domicilium? Canada. You are then married according to the laws of Canada. Despite the fact that you were married in South Africa, the South African laws in and out of Indian property will not apply to you at all, because the marital status of the place, which is the domicile of the husband, will be the law applicable to that marriage, which will be the laws of Canada. So that is why very often people get engaged, they run off, for example, to Mauritius or the Seychelles, whatever, to get married on the beach, lovely. They come back to South Africa, And these questions are asked. And they say, no, but we don't want to be married we want to be married according to laws of Mauritius. Or they say, that's where we got married. And according to their laws, you are automatically married out of native property. Well, sorry for you. And we didn't register ANC in South Africa before we went to the Seychelles for our wedding, because the rules of the Seychelles or Mauritius are out of native property. So that's why we didn't even register ANC, because we got married there. That's irrelevant where you get married. You will follow the domicile of the husband. The husband is domiciled here in South Africa, so you married according to laws of South Africa. Did you register the ANC before you went to Mauritius to get married? No, we didn't. We didn't think it was necessary because we're going to be married. No, you're not. You are married according to laws of South Africa, where the husband is domiciled. And because you didn't register an antenuptial contract before you went to Mauritius to get married, you married in native property now. So people must just understand that it doesn't matter where you get married in the world. Whether it's Mauritius, Seychelles, North Korea, South Korea, it's irrelevant where you get married. The laws of the husband's domicile will be applicable to that marriage. In Masnar, it was Canadian law, but just be careful when you are a South African and you travel abroad and you get married there, make sure that you register an antenuptial contract before you get married, because it won't be the laws of that country that will be applicable to you. It will be the laws of the country where you return to.
Hein, we just had a question, and I think it's actually a very relevant one from Sharon from our Durban North branch, who says, how would you know if he or she is married, but states to the agent that they're not married?
Sorry, so they state to the agent that they're not married. But
yes,
they are
so what she's saying is that they are married, but when the agent asks the question, they state that they're not married. So she said, how would you know if they are married or they're not married? Because obviously you've got to take the word of the client.
Absolutely.
But if the client is lying to you, how are you going to know?
Absolutely. Sharon, so yes, you do get those clients as well, I promise you. And I've dealt sometimes with them, where on the offer to purchase, they've told the agent that they are not married, for argument's sake. There is a way to pick it up, but it's very difficult. It's not easy. So you've got to take the word of your client. In our scenario, in my scenario, for example, I remember on the offer to purchase, it was, for example, unmarried. What we do is we obviously do deeds office searches on the seller and the purchaser to check and see whether that person is registered at the deeds office, whether they've dealt with property or anything in the past, because then we can pick up what the marital status was of their last transaction, for example, at the deeds office. And sometimes you can pick it up, but Sharon, at the end of the day, you've got to take the word of the client. And if let's say, for example, it's a foreigner that comes to South Africa. They are married in Canada, for argument's sake. Now the husband comes here and he comes in and he sees a property that he wants to buy. He says, look, I'm not married. I'm unmarried. We won't know whether he is married. We've got no idea. So, and there's no record of him at the deeds office. They don't have the detail of Piet Pompies, has never bought property in South Africa. So there's nothing. So the deeds office come back to say, hey guys, we don't know Piet Pompies. There's nothing here. So we'll take it as unmarried. And he can buy property and we'll describe him as unmarried because we don't know. But sometimes we do pick it up, especially if it's South African people and they own property. So in my scenario, I picked up that this guy was married out of property and he told me that he's unmarried. So I said to him, okay, sorry, man, can I just have your divorce order or the death certificate of your spouse? Because according to the deeds office, you are married out of native property. And I can see there that you entered into an antenuptial contract with your spouse in 2000. I see that you say that you are unmarried. That's fine. But I need to show the deeds office that you are now unmarried. So I need to provide proof to the deeds office, either a divorce order or a death certificate, because you're now saying you're unmarried. And the deeds office has you as married out of native property or in native property, doesn't matter, but I need to see. No, sorry, no. No, I am actually still married out of duty. So don't lie to me. Flipping hell. I could pick it up because there was record of him at the deeds office. Sometimes he doesn't need to have property registered his antenuptial contract. So if he registered his antenuptial contract in 2000, for argument's sake, and he's never bought properties or anything like that, when we do our deeds office search, we search all the deeds offices and we will pick up, hey, he's got an antenuptial contract registered in his name. So if he described himself as unmarried in the offer to purchase, the deeds office pretty much has him as unmarried as well. They've got an ANC, but he never earned property, so they don't know what his marital status is. But I will then ask him, but I can see that you're unmarried now in terms of the offer to purchase that you made. However, I see that you registered an antenuptial contract in 2000. What is the scenario there? Did you get divorced? Did your spouse die, perhaps? Because the deeds office is going to ask. The deeds office will come back with a note to say, hey, I see that this guy's buying property as unmarried, but there's an antenuptial contract. What is the scenario with the antenuptial contract? What happened there? Did he get divorced? Maybe he never got married? It's fine. But let him sign an affidavit that, yes, I registered antenuptial contract in 2020 or 2010. I never got married. That's fine. Or there must be a divorce order, or there must be a death certificate showing that the spouse passed away. So there are ways in South Africa to pick up little things, but there is no way, Sharon, if somebody comes from overseas or even here and tells you, let's say, for example, he's married in community of property, and he comes to you to say, I'm not married. You won't find anything at the deeds office because there's no antenuptial contract that registered to give us a hint that he might be married. He's married in community of properties. There's nothing at the deeds office. We've got to trust him. We've got to believe him, and we'll describe him like that. When he wants to sell the property, and he earned other properties, etc., we will pick up then that, but he was married in community of property actually for whatever, but not necessarily. So if he says he's unmarried, he buys and sells properties as unmarried, well, he's lying, it's fraud, and his spouse will have to one day decide what action she wants to take against him for doing what he was doing and lying about his marital status. But it is difficult. You've got to take it on face value. If your client says he or she's unmarried, you've got to take it as is. Sometimes it comes out that they are actually married, but that is just by pure fluke or chance. If they had other transactions in a deeds office, we might be able to pick something up, but not necessarily. So we don't go to the Department of Home Affairs and do a check on them to see what their marital status is. Not at all. We take their word for it, and we draft documents based on that. They sign affidavits with us confirming what their marital status is. And if they lie, they lie. And if they do something without the consent of the spouse can sue them at a later stage for being fraudulent, dishonest. But there isn't a fast rule as to how we can pick up whether they're married or not if they lie to us, unfortunately. Then if we have a look at civil union marriages, those are normally the same-sex marriages. The Marriage Act specifically defines a man and a woman getting married. So that is why the Civil Union Act came into operation, because the Marriage Act dealt with husband and wife, he, she, man, woman, which obviously couldn't cover us with gay marriages. So that is why the Civil Union Marriages Act, etc., came into operation to allow for same-sex couples to get married. So it's the voluntary union between two people. It doesn't say husband and wife. The Act says two persons. It can be husband and wife, absolutely, but it doesn't discriminate. It's between two people. Both must be 18 years or older, solemnized and read by way of a marriage certificate by a marriage officer. And again, it will be in or out of community of property, depending on whether they registered the antenuptial contract before they got married. Then they will be described. It can either be a civil union or a civil partnership. It's much of a muchness, but they can decide how they want to be described. Whether it's a civil partnership or a civil union, it's a marriage in or out of community of property. And we will just ask whether they had an ANC or not, because if they didn't have one, they are married in community of property. If they did have one, they're married out of community of property. And we'll describe them as such in terms of the transfer documents, whether it's in terms of the Deeds Registries Act or the Sexual Titles Act. They'll be described according to how, whether they're in or out of community of property, as easy as that. Domestic partnerships, and this is the last one that we're going to talk about very quickly. I know that we're running out of time, so I'm not going to waste time. A lot of people are under the impression that if you are living together like a husband and wife, you're not married, but you live together like a husband and wife. You buy property together, you buy your groceries together. The one pays the rates and taxes, the other one the electricity. You've stayed together for the last 30 years, like a married couple. Some people say, oh, my common law husband or my common law wife. There is no such thing. In South Africa, there is no such thing as a common law husband or a common law wife. Never. You will never be described as such in any documents at the deeds office. You are unmarried. You do what you want to do. You will never be seen as a common law husband or wife in terms of South African law. So it's important. If you do live like that, I'm probably one of them. But if you are in such a relationship and you are not married and you're buying property together, etc., you've got to enter into a partnership agreement with your partner. You have to enter to manage. How are we going to split the assets? What are we going to do? Because we are not seen as husband and wife. We are not going to get divorced, whether there is a divorce order, because we're not husband and wife. So we've got to enter into an agreement to say what will happen with the property. What assets are yours? What assets are mine? What assets do we own jointly? And how are we going to split those assets when the partnership break up? So it's important for people who live together, who are under the impression that they've got common law rights. You've got no common law rights if you stay together as husband and wife if you are not married. If you're not married, you are unmarried, you've got no rights and obligations towards each other unless you entered into a partnership agreement that determines what will happen. So I might say, but Lee, I bought R1 million into this. When we bought this property, I gave R1 million in cash, you gave 400,000 rand in cash. We need to put this in our partnership agreement. So if the partnership breaks up and we then have to sell the property, we've got to put it in the partnership agreement that I will get R1 million, you will get 400,000 rand, and then the balance of the monies will be split 50-50. Because we're not going to get divorced. We're not going to have go through a family court, etc., where we go and agree to these things. We've got to agree to this now. Because if we don't agree to this now and the partnership break up, then one of us will have to get a high court order to determine how the monies will be split up, etc., etc. So it's important to just understand there's no such thing as a common law husband and wife. They are unmarried. They do whatever they would want to do on their own. It's irrelevant, but it's very important to just advise them that they should enter into a partnership agreement that manages and deals with their assets and how the assets will be split and divided, that they obviously, which they have pulled together once the partnership is broken up. Because if you are in a domestic relationship or unlawful or a common law relationship, Whatever you brought into the relationship is yours. Whatever you acquired in your name during the relationship is yours. You can take it and duck. But the pooled assets, the assets that you bought together, the SMEG oven and hob, gas, electric, whatever that you paid 50,000 Rand for that you bought together, you need to deal with that as to how we need to split this. Should we sell it? Okay, you take that, I will take the little city golf that is sitting in the garage there, whatever. But you have to have an agreement, because if you don't have an agreement as to how things will be split up or managed, you will have to go to court and get a court order. But point being is that even if they've pooled stuff together and they own stuff together, they are not married. So in terms of your offer to purchase, in terms of transfer documents, they are unmarried. They're unmarried parties. So for us, domestic partnerships or common law, husband and wife, no such thing. You are unmarried. You've got no obligations or rights or claims for maintenance when the partnership breaks up. Maintenance can only be claimed against a spouse, an ex-spouse. So there's no claim for maintenance or anything like that unless you've put it in a partnership agreement and you've agreed there too. Then it is fine. Then you can enforce that between each other. But other than that, you can't. Guys, that is it. Thank you so much for listening to me. Michelle, I don't know whether there are any other questions. My screen is so small, man. I can hardly see a thing. So if you can see whether there's another question, I'm more than happy to answer.
There was just one from what wasn't a question. It was a statement, but it did give me a bit of a chuckle.
Okay.
From Bethlehem, where it says, sounds a little controversial that as a foreigner, you can purchase as an individual, but when selling, the spouse must assist. Now, I don't know about around the country, Hein, but we know what happens in Cape Town with these foreigners who meet local girls.
Absolutely.
That's what I'm going to say.
Absolutely. And very often, Michelle, those foreigners get quite upset with us, because they say, but look, Hein, I bought this property 5 years ago, married according to the laws of France. Now I want to sell the property. Why the hell do I need my spouse's consent now? Then we have to explain to them, because you are disposing. You're giving something away from your estate. And we don't know what the rules and regulations of France are. So your spouse must assist you, because the deeds office will not transfer the property if your spouse hasn't assisted you in selling this property. So yeah, it is what it is.
Well, we know why the foreigners buy the properties. Yeah, it's for their girlfriends. Yeah.
It's no wonder they get so cross when they need the consent of the spouse when they sell. I think you're right. Michelle,
let's not kid ourselves about what happens in Cape Town. Petrus had many of those stories.
Absolutely. Thank you, Michelle. Thank you, everybody.
Thanks, everybody. Thanks so much.
Enjoy the rest of your week.